Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Anora Wang. Today's topic is, are airline mergers taking off? Economic analyses of recent U.S. passenger airline transactions. Joining me today is my co-host, Kelsey Paine. Hi, Kelsey.
Hi, Anora.
So, talking about airline mergers, apparently something that's at a hot moment right now, but we're apparently going deeper. We want to look at that from an economic perspective. Why are we doing that?
So we've seen a lot of deal activity lately in the airline space with the recent Alaska Airlines acquisition of Hawaiian Airlines and the failed JetBlue Spirit merger. And now recently we even have an announced potential merger of Frontier and Spirit. So we spoke with attorneys who worked on the recent Alaska Airlines Hawaiian deal recently. And now we're excited to get the economist's perspective, including how economists evaluate the market and specifically what the analysis looks like applied to a few recent deals.
Very exciting topic. Who do we have as a guest speaker?
Our guest today is Gautam Gowrisankaran. He is a professor of economics at Columbia University and a senior advisor at Cornerstone Research. He has analyzed issues of market definition and market power, competitive effects of mergers, and claims of attempted monopolization. He's acted as an expert witness on behalf of both federal and state agencies, as well as private plaintiffs, including testifying for the government in the successful JetBlue Spirit challenge. He was also an expert witness for the airlines in the recently completed Alaska-Hawaiian merger.
That's very exciting to have you, Gautam. Welcome to the program.
Thank you. It's a pleasure to be here.
So in antitrust, we talk about a relevant product market and relevant geographic market. So passenger airlines is a context where we often look at airlines competition over certain routes, meaning specific and unique combinations of departure and arrival locations. So here, should the product be the scheduled air passenger services over particular routes? And then should the geographic market be limited to those pairs of locations?
Well, those are great questions. And, the market definition for any merger, any transaction is a fundamental part of antitrust analysis. And it really boils down to an analysis of substitutes. And in a market, what you want to do is to show that substitutes that are most important are in the market and ones that are not as important are not in the market. The relevant geographic market that I have seen in these airline mergers is origin and destination city pairs. So, an example of a city pair product market is flights from, say, Boston to Miami, Fort Lauderdale. And I put Miami, Fort Lauderdale together to indicate that there's really two cities there, two airports within that same city of Miami and Fort Lauderdale. So why do we think of that as a relevant market? Because when you're thinking of traveling, then you typically have an origin and a destination in mind. And so let's say you're a family in Boston, you want to go on vacation to South Florida, then you're going to look at flights from Boston to Miami, Fort Lauderdale. And if there's a really cheap flight from Spokane, Washington to Denver, that isn't going to help you a lot. In terms of whether we should think of there being substitutes from outside the airline industry, so for instance, on relatively short flights, one might think that, for instance, taking Amtrak could be a good substitute, or driving could be a good substitute. There's just potentials. In the JetBlue Spirit analysis, I took that point and I did a test to say, are there enough airlines within this market? Is there enough competition within this market of airlines to constrain prices, or do we have to consider trains and driving? And I found that there are far enough substitutes that we didn't have to put them in the market. And then it sort of goes by reason that if you look at a longer market like New York to Salt Lake City, you sure aren't going to drive there for that one.
So now that we've talked a little bit about city pairs and potential substitutes, I want to focus on the product element for just a second. We're familiar with the big four or legacy carriers in the US, which is, of course, American, Delta, United, and Southwest. But there are also these smaller, more regionally focused airlines like Spirit or Hawaiian. So in the context of merger analysis, does it make sense to further narrow the market definition by major or smaller airlines, or by budget and premium flight services, or simply divide it into sub-markets that may offer some other unique draw?
Well, those are really great questions also. If we look at the JetBlue Spirit merger, then JetBlue and Spirit are not one of the big four airlines that you mentioned. But despite this, in their cases, they were competitors to the big four airlines. And so what I assessed in that merger in that proposed merger, was that you really couldn't split off the big airlines from the small airlines because they were competing with each other. The same goes for Alaska and Hawaiian. So they're also not one of the big four airlines. But for instance, Alaska and Hawaiian they're competing with Delta, which on routes such as Seattle to Honolulu, because Delta also operates on those routes and customers make choices between those airlines. So I think in both these matters, fundamentally, it doesn't make sense to exclude the big four airlines because they're bigger and serve more routes than the airlines that were at issue. The second part of your question was really, should you think about potential submarkets within that? And, it's always useful to think about submarkets. In particular, for instance, Spirit is an ultra low cost carrier. And so thinking about the impact of competition for ultra low cost carriers and the passengers that might choose them, the price conscious or cost conscious passengers, is important. In my case, I didn't define separate markets for those travelers, but the principle of market definition says that there's not necessarily a unique market that might work for a transaction. It's not a matter of precise meets and bounds, is what the merger guidelines say.
Antitrust law focuses heavily on price as a measure of competition, but non-price competition, like you mentioned, quality of service, customer choice, that also matters. So how do you think about non-price competition when evaluating the airline mergers? And is this why we have to pay for seat assignments now?
Well, this is, I think that as a broader point, as economists, we don't just care about prices. At a most basic level, we think of quality or value that customers get as one of the attributes that they're picking on. And when we talk to other economists, we often talk about quality adjusted prices, which is say what would be the equivalent price for a customer if they got certain features with their product, whatever that product may be. And so absolutely, as economists, as a general point, we think that competition is really about a broader perspective on firms than just the price. Thinking about the airline sector, when I analyzed the JetBlue Spirit merger, what I saw from all of the evidence on Spirit's customers and on Spirit's on Spirit's testimony and stuff was that, and Spirit's documents was that Spirit customers, above all else, cared about price, and those customers did not put a big premium on anything other than price. So mostly those customers, they didn't really care about the free Wi-Fi or having free. Those customers, they didn't care about having free Wi-Fi. They wanted cheaper tickets and they wanted to get where they were going for the lowest price possible. And that's the specifics of that transaction. But, every different transaction and every different set of customers, there's going to be different specifics. And what matters as an economist is to look at those transactions and try to understand that.
Okay. So we're very much in the weeds already, but just to provide the listeners a little bit of context, and let's embrace the facts and details of the recent mergers that you analyzed as an expert a bit more. So in JetBlue's proposed acquisition of Spirit that was announced in 2022, which was challenged by federal and state enforcers and litigated, I think, in 2023. And then the parties abandoned the deal, I think, in 2024. And there you served as expert for the government and analyzed the effects of the proposed merger. And your argument there, I think, was very much focused on competition in certain metropolitan areas or competition over specific routes rather than the national market, like the defense has argued for during trial. And let's just have a little more understanding. Why is that, and what's the basis of the argument?
So when you look at the JetBlue and Spirit merger, then what the defense argued, I think, in their opening statements, and correctly argued, was that these were not among the four largest airlines. That JetBlue was number 5, I think, and Spirit was even further down there behind Alaska, maybe number 6 or 7. And so I agree with that completely. That's factual. But the defense then argued that because of that, maybe we didn't have to worry about a merger between those two airlines. And that's where I didn't agree with them, because the fact that JetBlue and Spirit are not that big nationally, or not the biggest, does not mean that they're not big on particular routes. And if you look at routes like, the Boston to Miami example I gave, or Boston to Orlando, or in a lot of cases, they have routes from South Florida. They both had routes to Latin America, like to Colombia. Then they're big on those routes. And on those routes, they provided a lot of the market shares. And if the merger had gone through, you would have gotten rid of a lot of that competition, and which I think would not have been good for consumers. And so I think the bottom line here is that, if you're flying from Denver to Spokane, to take an example I gave earlier, you don't really care about a JetBlue and Spirit merger, because neither of them fly that routes. But there's a bunch of routes where where both of them fly, and where this merger would have reduced the competition on those routes substantially. And I think, and that was my opinion, I think Judge Young agreed with that general point, because he ended his decision by saying, it was almost a poem, and it said something like, there aren't that many customers that fly Spirit, and it's a relatively small airline, but he said this, he's blocking the deal. He said, this one's for you, for those customers. And for those customers, it was going to mean higher prices.
Well, thank you for that. And it seems that in JetBlue and Spirit, it seems that the heart of the case for the government, at least, was 51 or 34, a particular number of nonstop overlap presumption routes. So that's mouthful. My personal opinion, any market definition that's longer than 4 words, it's very hard to convince your listeners to be on your side. But would you unpack that for us for a little bit? What is the presumption? I think that supposedly that meaning that's over the presumptive level of concentration in the merger guidelines, right? But why was the government most focused on this bit, on this subset of routes that the two airlines compete with each other and with others?
Yeah, absolutely. And I think the number in my report was 51, and I remember that because I was 51 years old when the process was happening. So I remember that; it stuck in my head. What do we mean by this? These nonstop overlap presumptive routes, and why should we care about that? Well, let's start with the first part of that, nonstop. So nonstops are, a lot of the business for Spirit, something like 90% is nonstop, and JetBlue is also fairly a fairly big nonstop carrier as opposed to connecting hub and spoke carriers. So that's why we start with nonstops, because that's a lot of their business, is people flying one flight from an origin to destination. Then in terms of presumptive routes, what we mean by presumptive routes are ones where the technical word is something about the Herfindahl index being over 2,500. But what it really means is these are routes where there are relatively few competitors operating on that route. And so, I gave the example earlier of Boston to South Florida, and that's an example of a presumptive route. And what I mean by that is that that's a route where both JetBlue and Spirit operate nonstop, And it's a route where there isn't a lot of other firms that are operating that route besides those two, or those firms that are there, they have relatively low market share. So we care about these routes in particular because when these two firms, in this case, are big in those routes, and that represents a large loss of competition, of potential competition from the merger. Okay, and so that's where we want to start investigating potential adverse impacts of the merger. And it's a mouthful, I understand, but it's kind of common sense as well as good economics that if there are two airlines on a particular route and they have a big market share on that route, then if they merge, you're going to see a big loss in competition potentially.
I understand that during trial, and you already talked about the Herfindahl-Hirschman Index, or HHI, as people in antitrust understand, and that's a presumption of potential competitive effects that the government is looking at. But in JetBlue Spirit particularly, the defense highlighted changes to a number of these nonstop overlap presumption routes, including exit by Spirit or JetBlue from some routes. So how do you think about that presumption or presumptive competitive effect when the carriers serving a route is actually changing over time?
That's an excellent question, and it's absolutely true. I think that I identified 51 routes that were presumptive nonstop overlaps, if I remember. And, I used the most available data that were available when we started the investigation, and data for which we also had prices and stuff. But by the time of the trial, you could look at what the plans of the carriers were going forward for that year. And I think that in cross-examination, the JetBlue and Spirit attorneys showed me that, on something like 10 of those routes, one or the other of the carriers had exited, so they were no longer nonstop presumption routes. And on 8 other routes, one or other of the carriers had entered, and so it created new routes. And I think that just goes to show that, airlines do enter and exit routes. And, as an economist looking at data and trying to analyze competition, we do our best by looking at a snapshot in time to say, in a particular time, is there likely to be is there a presumption of likely harm? And then what we want to do is to say, let's look at that snapshot in time, but let's extrapolate to the future to say, if this merger were to the but-for future, if this merger were to go forward, what do we think is likely to happen? Is there still likely to be routes where a lot of routes where there's a presumption of harm, or are they going to just go away? Right. And you're going to see when in an industry like airlines, where there's a lot of routes and there is entry and exit, that companies do respond to competitive pressures and to profit opportunities by entering and exiting, that the industry is not static. Okay. It is changing over time. But what I found in this particular matter was that even though it's changing, the big picture on this, which is that JetBlue and Spirit were head-on competitors on a lot of routes, and that the merger was going to lead to presumption of anti-competitive harm on a bunch of those routes, was still going to be true in the future. So even though the precise nature of the routes is going to change over time in a sector like this, you want to really look at the longer run and dynamic impact of this, and look at the snapshots of competition to inform us about what's going to happen over that longer run.
So we've talked a lot about the JetBlue Spirit transaction where you testified on behalf of the government. But in another case you worked on recently, Alaska Airlines merger with Hawaiian Airlines, which was completed in September 2024. You served as an expert on behalf of the merging airlines. So you testified against the airlines in one case and for it in another. How do you think the two transactions are different?
Well, that's a great question. And I think let me start from the highest level on this, which is I teach my students at Columbia that there are really valid reasons, pro-competitive reasons for mergers, that in many cases you can have mergers because, for instance, you might have products that have synergies with each other. There are products where If you merge, it might provide benefits to consumers. There are other cases where you can use mergers as a way of getting more capital for firms or getting better management. And there are also cases where mergers are going to lead to anti-competitive harm to consumers, to benefits to firm profits that come at the expense of consumers and that lower total welfare. And as an economist, I take seriously that the job of economists is to provide models that help the government and help policymakers, help society assess which mergers are likely to be beneficial and which mergers are likely to cause harm to society. And the goal of antitrust regulators should then, and of courts, should then be to challenge the mergers that are harmful, that lead to an exercise of market power, while approving or not blocking the mergers that are really about the better exercise of competition. Turning to these particular mergers, I think that in the JetBlue Spirit matter, the biggest issue in that matter was that this merger was going to lead to consumer harm, and I assessed that in my trial testimony that a conservative estimate was that consumers would pay $900 million more in prices for airline tickets because if the merger were to go through because of the merger. And I also assessed that in that particular transaction, what was most important to consumers, especially to the consumers that picked these ultra low cost carriers like Spirit, was in fact prices. And so that 900 million of higher prices was in that instance a good measure of the harm to consumers from the merger. Now, turning to the Alaska and Hawaiian merger, Alaska and Hawaiian are different products from Spirit, and in fact, somewhat different even from JetBlue. They both operate in in sort of a midpoint in space where they have some premium features. So, for instance, I've never flown on Hawaiian, but I understand that when you get on, it's, for many customers, it's like the vacation is already starting when you get on, and they'll offer you a Mai Tai, a drink, when you board the plane, and, that kind of thing. So it's meant, and I think there's a lot of loyal customers for both Hawaiian and Alaska because of these particular features. So when we were investigating, and it's not just that, of course, though, like one of the things about Hawaiian is that their two hubs were in Honolulu and in Maui at Kahului International Airport. And, while Hawaii may be a vacation destination for many people, it's also, Honolulu and Maui are cities, and there's business travelers there. And those business travelers value connectivity. And so what do I mean by connectivity? Business travelers have been shown in many studies of airlines to value airlines that offer a breadth of network, that offer frequent service. They might value those for a whole bunch of reasons. So if there's more frequent service and their business ends early, they can get back to, get home with the kids and not spend another night or not spend a whole day waiting. Or if you have more destinations, you can coordinate and fly the same airline for those destinations. If it's a hub, then, and, say an airplane breaks down, well, the airline's likely to have mechanics on site and spare parts and spare planes. And so you can get where you're going more quickly than otherwise. So in the Alaska and Hawaiian transaction, there were, I looked at this and I found that there were a substantial number of connectivity benefits that would occur from that merger, where essentially it would make Honolulu and Maui much bigger hubs by including many more destinations that people could go to with one stop, or in some cases with non-stops. And it would also increase the hubs of Alaska at Seattle and Portland and other West Coast airports by adding more flights to Hawaii, and in some cases more destinations to Hawaii. And so overall, what I assessed is that merger was going to be beneficial to consumers because of those connectivity benefits, which were important. And that's a very different situation from the Alaska and Hawaiian that's a very different situation from the JetBlue and Spirit potential merger.
Thank you, Gautam. That's all very helpful. Since you are in hot seat, and I want to make sure that we do engage the counter argument a little better, and using JetBlue Spirit as example to talk about market share calculation a little bit more. Some would say the two merging parties' market shares were too low for the government's challenge to begin with. And I think he would say no. But just to give the listeners a bit more context, in that case, the government looked more specifically at several types of routes, including the nonstop overlap routes where concentration levels met the presumption for harm, as well as routes where Spirit or JetBlue, one of the other, is not serving those particular routes. But why is that? Why is it important to look at those routes where Spirit and JetBlue market shares were not enough to trigger a presumption for harm?
Well, that's a great question, Anora. And so starting with, again, the big picture, a presumption is just that. It's saying that, you're likely that there's competitive harm on those routes. It neither says that there's definitely competitive harm on those routes, nor does it say that there's definitely not competitive harm on other routes. So as an economist analyzing a merger, I often want to start with a presumption or present, evidence on what presumption is, but I wouldn't want to end there necessarily, because I'd want to look at a bigger picture. What are we finding about competition? When I looked at this particular transaction at a bigger, and said, when I tried to say, like, as a whole, what do we find? Well, sure enough, when I talked earlier about how I assessed that conservatively there was $900 million in harm to American consumers each year. Something like 700 million of that was on these nonstop presumption routes, right? So it was the biggest part of that, but it wasn't the only part of it. And so there's a bunch of reasons why that's true, why there was harm elsewhere. The first is that, there are other routes where, for instance, JetBlue and Spirit both operated, but they didn't meet the threshold for presumption. So there was just a little more competition. But because of the nature of competition on those routes and the nature of those airlines, I found that there would in fact be competitive harm. But there's another point, and that's very specific to this transaction, and again shows that in analyzing a particular transaction as an economist, I don't just want to hit a button and say, okay, this is the answer, the Herfindahl, the HHI is above this level, so there's harm, below this level, there's not. You want to look at the details of that transaction. And in this particular case, looking at what the plan was for this merger, JetBlue said that it announced that, it wanted to buy Spirit, not to keep the Spirit brand as an ultra low cost carrier, but rather to take those Spirit planes and essentially paint them blue, essentially use them to expand the JetBlue brand. Because of that, what that meant was that even on routes where Spirit operated, but JetBlue did not operate, there was a potential for consumer harm because you were removing Spirit, which is an ultra low cost carrier, which is the largest ultra low cost carrier in the U.S. at the time, and replacing it with JetBlue, which can generally be thought of as a low cost, but not an ultra low cost carrier. So it's that specifics of the transaction here that meant that even on routes where just Spirit operated, there's this potential for consumer harm.
And we talked a lot about nonstop overlap routes, and part of that analysis is whether or not there might be entry on those routes in the future. So a critical part of merger analysis is whether there'll be timely, likely, and sufficient entry or repositioning so that competition is not lessened. And again, taking JetBlue Spirit as an example, and I know there was another expert for the government testifying on this particular issue, but what was the key contentious point about entry here? And was it important to identify potential entry in every single identified route, or was it more of a totality of circumstance analysis?
Well, that's a great question. Again, as you noted, I didn't testify on entry. Dr. Tasneem Chipti did testify on entry. I did read her reports and I did see the judge's decision. And what Judge Young found was that the entry that would occur was not likely to replace the loss of competition from the potential merger between JetBlue and Spirit. In terms of like the specifics, my understanding of it was that JetBlue had announced that if they were to merge with Spirit, then they would divest certain assets to either Allegiant or Frontier Airlines, which are the two, the second and third biggest ultra low cost carriers. And those assets included some gates, I think, at Fort Lauderdale Airport, and also included a couple of slots, but a very small number of them at LaGuardia. And I think those were the main parts of that were divested, to my recollection, and it wasn't something I testified on. And I would say that the contention came from the fact that of understanding, like, are these really the assets that were divested that were the most important, and would these assets result in a restoration of competition on the particular routes where there would be a loss of competition? In other words, were these airlines like Frontier or Allegiant going to use those assets, use gates at Fort Lauderdale to lower prices in the Boston to Miami Fort Lauderdale route if the merger were to go through? Or would they use it on completely separate routes where it would not restore that competition?
And then just to compare sort of how entry was looked at in Alaska Airlines and Hawaiian Airlines, to the extent that you can speak about it, how was potential entry evaluated there, given that the pertinent areas were relatively very remote?
Yeah, that's a great question. Again, speaks to why you really want to look at specifics when you're looking at a merger. So I studied those markets and studied the industry for Alaska and Hawaiian. And Alaska and Hawaiian operate with their hubs and focus cities on the mainland U.S. West Coast and in Hawaii. JetBlue and Spirit, most of their hubs, most of their overlap were in the East, in places like Boston and Miami. There was just a world of difference in what I saw between the markets that were at issue. So the biggest markets in the U.S., like New York, LaGuardia, and other New York airports and so on, are slot constrained. And that means that there's a certain number of slots. So here in New York, the Port Authority has slots for airports, particularly LaGuardia, which is very congested. And those slots are on long-term leases to, Delta Airlines, American, in some cases, JetBlue, Spirit. But, you can't just go in to the Port Authority and say, I've got a new airline. I want some slots. I want to start flying. They'll be like, okay, well, that's great. Go ask American if you can buy some of their slots from them. And, I don't know that American's going to be super likely to give up their valuable LaGuardia slots or other slots. And even in the airports which are not slot constrained, like, say, Boston's Logan Airport, there are substantial gate constraints. And the gates there, in many cases, are done with long-run leases. So, you don't need a slot to land at Logan, but you do need gate space. And again, those gates are going to be on these long-term leases. Now, let's contrast that with the West Coast airports. So generally in the West Coast airports that I studied, they are happy to lease gates. There's no slot constraints in the West Coast airports to start with. And they're happy to lease gates on the short term. And they, in fact, in many of those airports, they'll have both specific, like, preferred gates and also general use gates. And general use gates mean, if I go to SeaTac, Seattle's big airport, and I said, I've got an airline, I want to start flying out of SeaTac, can I get a gate? And they would say, sure, we've got general use gates. This is the price for a general use gate. When do you need it? We'll see when it's free. Not only that, but in many cases, including SeaTac, including Honolulu, they have opened or are about to open big expansions of gates, meaning that there isn't the same constraints of new entrants that we see on the East Coast airports. In other cases, like Portland's airport and Maui, which is still suffering from the fires, the traffic at those airports is not back to pre-pandemic to 2019 levels. And so they have gate spaces. So it's not just that when we look at those airports, there's the potential to have entry. When I studied it and I looked at the data, what I saw is that in those airports, there is a lot of entry and a lot of exit that you just see on a whole bunch of routes, new carriers coming in, trying routes, in some cases making a go of it and staying, and in other cases leaving because it wasn't successful. And that's the natural forces of competition that we'd expect, that if there's a profitable opportunity, firms can enter. But when you look at the East Coast airports, because of the constraints and the congestion, you just see a lot less potential for entry and a lot less entry because of that.
This is all very helpful. This is as close as I can get to a simulation, I guess, of a merger analysis that can be from an economist's head. And before we let you go, we do want to know you a little bit better from a personal level. So would you please tell us something about yourself that we would not know if we have only known you in a professional setting?
Yeah, absolutely. So people who know me personally know that I'm Canadian. And it's not, obvious from my name. And not only am I Canadian, but I'm born and grew up in Montreal, so I'm Québécois. And not only am I Canadian and Québécois, but I love the French language. And so I speak, my family, my kids and I speak together just in French all the time. And I don't think you'd know that from my name, but some of my Québécois friends, they have they have me as a nickname. Instead of Gautam, they call me Jean Gautam, because Jean is a very Québécois name. So
I would not have known that.
There you go.
Well, okay, before we let you go, and since we're doing this video, and this is going to be comical, we're going to bring you to a segment called Our Curious Hat.
And now it's time for the Curious Hat.
The reason I want to do this is because we're doing video, and we were telling people that, since we're recording virtually, we don't actually sit together, we don't actually have a physical hat. Now I'm actually going to present you the virtual hat, where you can pick a number from 1 through 19, and I'm going to tell you what question would correspond to that number you picked.
Okay. Well, my youngest daughter is age 14, so I'm picking that.
14. I think that's the question we have here. Do you like to dance? And if so, how would you describe your dance style?
Oh my gosh. Well, what I'll say is that when I was in college, I liked to dance. And if you ask my closest friends, they'd say I shouldn't dance because I'm not a very good dancer. It's embarrassing to watch me dance. So,
well, it could be.
I still sometimes like to dance, but I don't think my friends like to see me dancing.
Oh, well, I guess you should probably find some new friends, or drink a little bit with them. They would have a better appreciation. Thank you so much for joining us. And that's all for today. And thank you for listening and also watching.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.